First question, which I think is great, great first question, is what is intellectual property? What is IP? And more importantly, what it is not. Intellectual property, based on my definition, is the execution of an idea that was thought of, not the idea itself. You cannot copyright an idea. I can have the idea of saying, I'm going to go ahead and have something called the Bring Your Worth Show, and I'm going to be connecting with people twice a week. I can't copyright or have intellectual property around that idea. But me executing the idea, which in a meta way I'm actually doing right now, me actually having this show, this actually being a product, a service, a thing, this is intellectual property. I own this show. This is in my family's name. That's the difference. So when people talk about IP or intellectual property, they're not talking about the idea. The idea doesn't mean anything, frankly. Respectfully, whatever big ideas you have, they're fantastic. But you can't hold ideas, you can't copyright ideas. And if eventually over time, you can't even tell who came up with the idea first. Right now, we're celebrating hip hop's 50th anniversary. It just turned 50 about 2-3 weeks ago in August, right? Because it started in 1973. No one can copyright hip hop because it's an idea. Now we attribute it to Kool Herc over at Sedgwick Ave and all those things, if you know your hip hop history back in 73. But we attribute it to him, but we don't actually know, like it's not copywritten. But Grandmaster Flash and the Furious Fives, The Message, that's intellectual property. That's putting hip hop into a context and saying, here it is on a vinyl, on a record. I'm dating myself, but that's how it came out, on a record. Here it is on a record. Here it is on a cassette tape or 8-track. That is actual intellectual property. And so if someone did something with Grandmaster Flash's and the Furious Fives, The Message, like Ice Cube or whoever, sampling it later, which means they take a piece of the song and they turn it into another song, they have to pay the copyright owners, the people that own the intellectual property, a proper amount of money based on what they negotiate. That's intellectual property. Now, a key thing that there's a lot of discussions about I do videos about intellectual property, again, at bringyourworth.tv. There's a whole playlist about intellectual property. And then there's also some things about contracts. And in fact, I have some ultimate guides about contracts. All the links are below, or you'll see them on the side in the chat. If you see some of the discussions in the comment section, there can be some argument and confusion where it's like, oh, well, as soon as we create something, then we own the intellectual property, so we should own it forever. Maybe in a universe way, maybe in an ideal world, to be honest, but that's not how it works. When we sign a contract, when we decide to distribute something through say, Sony Music, if you're a musician, through Penguin Random House, because I've been an author many times over, I've done a bunch of books with Penguin, you see him right behind my head, you sign a contract with Penguin Random House or whatever. Once you do that, then your intellectual property isn't based on you just creating something. It's actually based on whatever contract you sign. So that's why you see artists, again, Prince. I have a couple videos about Prince at bringyourworth.tv. You can check them out right now, that talk about how he had to fight to get his intellectual property back. About Michael Jackson, him trying to get the rights back and even getting the rights to some of the Beatles catalog for a long period of time until after his death. All those different things mean that we need to separate the person who's creating things and our artistic right from making something from what we decide to give away or share, what we decide to partner with to get something distributed. Now, I own my own publishing company. It's Bring Your Worth. That's why I talk about being indie. So it's a complete Bring Your Worth collection. It's under my family name. If you go to Library of Congress, you'll see it there, right? Under the Brown name. So I'm not giving away anything. But if I were to work with, say in my last book, I worked with Union Square, which is a part of Barnes & Noble. And so it's my book, Career Remix. If you're a long viewer of the show the last year or two, you've heard me talk about it a lot. This came out about 1.5 years ago. I share the intellectual property with Barnes & Noble. That means I don't have 100% ownership of it, and neither does Barnes & Noble. We share it. But that's based on the contract that was signed. So technically, I wrote every single word in the 6,000 word book, or sorry, 6,000, 60,000 word book. It's not 6,000, 60,000 word book. The point is though, when I decided to get it distributed, I decided to share some of those rights, share some of that intellectual property. And based on what was negotiated with myself as well as with my agent, shout out to Marilyn, we were able to figure out a way that was equitable for everybody. But just because you create something, that doesn't automatically give you intellectual property rights until it's executed. And then once it's executed, it depends on what rights you might share with the people that are helping you get it out there, right? So if the Rolling Stones have a deal with, say, Columbia, they can be making all this great music, which they do make great music. They're classic. They are sharing that intellectual property of creating that music with Columbia or whatever label they're happen to be with. And that's based on how to negotiate. Hopefully that's clear, but I think it's really important to separate those things, because sometimes we feel like it's unfair because we're artists and we want to create things and I created something, so I own it. Well, yeah, as soon as you create it, you own it technically. But if you actually want to get out into the world, or if there's other facilities, like say if you end up working with a Sony or a music label, and then they end up saying, okay, we'll put you in the studio. That studio time isn't free. You might be giving up part of your intellectual property to do so. Keep that in mind as you get involved with different contracts, because it's not just the nature of, again, the business, but the business of the business. And there's so many artists, including some that I've coached over the years, that end up signing contracts and didn't realize what they were getting into. That's the difference between having an idea and then the intellectual property is actually the execution of that idea. And your rights around that idea that you execute is based on whatever contracts you sign or don't sign. Really important distinction there. You got to keep that in mind. I'll get off my soapbox on that, but hopefully that's clear. Such an important part of things, because we put our blood, sweat, and tears into these things, and then we don't realize what we're giving away. And I've signed some rough contracts, so I speak from experience. A good place to start is I did a series of shorts earlier this summer. Understand intellectual property in 10 shorts. 10 shorts, if you're not familiar, are similar to TikToks or Instagram Reels. They're 60 seconds or less, and they talk about one particular topic. I have a few hundred shorts on my channel, so feel free to check them out at bringyourworth.tv. I collected all the shorts that have to do with intellectual property, though, and put them onto one compilation. I think it's only like 7-8 minutes long. It's very brief. It goes over some of the things that will help you navigate your artist contract. We'll get more into some other resources too, but this is a great place to start. Again, it's only a few minutes long. They're shorts. So I'm explaining points and percentages. I'm explaining royalties. I'm explaining advances. I believe there's quite a few topics I'm explaining. Work for hire. So many topics that we see it in a contract and we can get intimidated or confused, or worst of all, just ignore it and just sign the contract. You gotta know what's happening, particularly if you're gonna bust your behind and get your work going. Book I recommend, and not just because I made it with my colleague Jeanette Hurt, is The Passive Writer. The reason why this book is important is because we end up breaking down different ways that writers, and I'm a former journalist, still am, but it used to be my full-time job, how journalists like myself can do independent work, can write, and then still own some of that work, some of that intellectual property that we do for these major magazines, and then do more with it. My first major business book was The Bite-Sized Entrepreneur, the one that's featured in the complete Bring Your Worth collection that's coming out in a few weeks. So it's all in there. And some of that content began with my column with Inc. magazine, which I was way more active with at that time. I've slowed down a little bit, but I still have a column with them over at inc.com/author/Brown Damon. My point is that depending on what contract I end up signing with Inc. magazine, I might not have been able to, I could have done a column with Inc., had a great idea with it, and I'm like, you know what, this could work really well as a book. And then Inc. could have said, depending on the contract, they could have said, no, you can't do that because we own that because you did this column for our magazine. Instead, we ended up negotiating a contract so that they had ownership for a set period of time It's called first rights. They had ownership for a set period of time, and after that period of time, I can do whatever I like with it. And there's so many other things that I've done with getting that intellectual property back. So be conscious as far as what you might be doing or might not be doing with your work. You know, Jeanette and I's book gets all into that, where it's like we sometimes sign things or we end up committing to things and we don't realize, oh, 5, 6, 7 years later, I started my ink column in 2015. So years later, all of a sudden I have best-selling books based on some of the ideas that began while I was working with them on the column. But if I didn't negotiate things right, then I would have had all kinds of challenges. So be careful with that particular path. Again, I'll get off my soapbox on that, but it's so, so important and essential to the work that we do. Again, it's Bring Your Worth TV coming to you every Wednesday and Sunday at 1:11 p.m. Pacific Standard Time, Vegas time. Today, we're talking about artist contracts, and I'm going to y'all live every weekday. You can kind of probably hear my kids in the background. So this is live and direct. And we're hustling here. We're doing our thing. I'm trying to help you level up with your creative contracts going into the year 2024. To be frank, though, a lot of stuff I'm talking about here applies to any year, but we're talking 2024 now.